Well, you've seen Brian Claypool on Fox and elsewhere. He's a highly regarded trial attorney, defense lawyer. Nice to meet you, Brian. How are you, sir?
Great, Mark. Nice to be on your show. Thanks for having me.
I do a lot of constitutional stuff. I have to admit I'm perplexed, and I don't pretend to know all the ins and outs of the law in New York and so forth, but how the hell did the Access Hollywood video wind up in this case?
Yeah, that's a great point. I was on Neil's show, Cavuto's show earlier today, and he asked me what are some issues for appeal, right? And to me that is the ticket item for an appeal. I tend to agree with you. You know, some analysts were like, oh well, the laws are such that you can bring in comments made by somebody, right, that for propensity, right, to show that somebody has a propensity to do something. But there's two issues I have with that. Number one, look at the context in which that those comments were made by Trump and I forget the guy's name from Access Hollywood.
Right.
You know, they're chit-chatting. There's nothing specific that Trump said about a person, a woman. It's just a general comment, right? And then the next problem I have with that is this: in jury trials, whether it's civil or criminal, even if a judge decides that a piece of evidence like the Access Hollywood tape is deemed relevant to the case, right, the judge still has to do an analysis as to whether any undue prejudice outweighs the relevance. And if the prejudice does, you don't let it in. And that's where I have a problem. I mean, any juror that hears that tape, I can't see how they would not find Trump guilty. It's just extremely prejudicial.
Particularly when you're talking about a jury in a city where about 7% of the people voted for Trump. I mean, it's obvious that plaintiffs' counsel, and I will argue these prosecutors too, they're playing to this. They know that he's largely despised by the populations in these various metropolitan areas, that his support comes outside of those areas. So to your point about prejudicial, it's prejudicial in the specific way in which it's used, but it's prejudicial because it's really pouring fuel on the fire where people are going, wait a minute, I knew I didn't like this guy. Now, there were two women who testified who have absolutely no connection to the facts of this case, too. How did that happen?
Yeah, I mean, I handle sexual assault cases and sexual abuse cases. So, I mean, I've actually represented, and I do represent victims of sexual abuse. And I still, even though I represent victims of sexual abuse, I'm still troubled with how the laws have developed in states like New York, California. And what I mean by that is that laws are becoming more lenient to let in evidence, for example, of prior encounters that a defendant has had with other women. Now, years ago, Mark, that evidence clearly would have not come in. It would have been because it's what's called inadmissible character evidence, right? You're attacking somebody's character. You're trying to say they're a bad person on this occasion to prove that they were a bad person on the occasion at trial, and that's the risk you run with these new laws. I mean, these two incidents with these other ladies, they're vastly different. I said that on Neil's show. This wasn't a case of with the other two women of, for example, Trump being at a bar and they're drinking, and then he takes them back into a dark hotel room, and forces himself on them in a locked hotel room. It was just different. I mean, these two other incidents were not really similar to Carol's incident. So it is a bit troubling.
Well, isn't it also problematic in another way, which is what he's supposed to do? Have many trials on these two other cases? Nobody's been charged with anything. Trump wasn't charged with anything respecting these two women. Who knows if they're telling you? What are you supposed to do? Hold a whole set of depositions and so forth on the side here to check their credibility and so. I mean, how would that even work?
Yeah, I mean, you're raising another good point, which is these other two women now are coming into court. And by the way, I think Trump's lawyer made a point to the jury that they were Democratic as well. They're anti-Trump, and you're right. Where is the veracity of these two encounters that these two women have claimed? Did they file, for example, a police report? Did they? I mean, if they didn't, to me, if I'm sitting in a jury, I start wondering, whether it really happened. Did those two other women run to other friends or other people and disclose? Was that talked about, right? Because disclosures are really important in sexual abuse cases. Was that delved into? And then you've got to look at something you raised earlier, which is what is the political affinity of these women? I mean, what's in it for them, right? Think about that. Why would they come forward after all these years? I think one of the ladies was like back in the 70s. She said something happened. All these years go by, and then all of a sudden, you're going to walk in and say this happened. So, it is troubling. And what I like to see in these cases is a fair playing field. Let's have the evidence in a manner where it doesn't facilitate like a political kind of attack on somebody. And I think this case should have been just about what Carol said happened, right, in that dressing room, and that's it. That's my view.
And isn't the problem with that it would be almost impossible to make a case if it's limited to that? That's why they had to bring in all this extra information, if you will. Now, I'm sure my audience is sitting there and wondering, well, how would a jury be able, with the limited, serious limited information it had, to find guilty on sexual battery but not rape? What exactly did this jury have? What information did it have to be able to distinguish? I want to hold you over, if you don't mind, to be able to distinguish between one or the other, because I haven't heard anything. I know there's a different proof issue, but any proof, how would you, if you're going to believe the plaintiff, and if you're going to believe what she told these two friends, then how can you say, no, it's not rape, it is sexual battery? So I believe them to a point. I'm just curious what you think about that. Brian Claypool, longtime trial attorney, defense counsel. So to reiterate my question, how would this jury know if one physical act occurred versus another physical act when all they have is what the plaintiff said, and then they're not really believing the plaintiff because they didn't go as far as the plaintiff said that she claimed she was attacked?
Hey, Mark, actually, that's a great point, because it suggests that what the jury did back in there is that some jurors might not have agreed with her version at all, right? And some were saying, oh, no, I believe that President Trump raped her, right? So it connotes that maybe jurors met in the middle, right? So you pulled some in from who thought he raped her with some that said maybe he didn't. And that's not a proper way to conduct a jury deliberation, to your point. Because if she's saying, I was raped by President Trump, she's not saying, I wasn't raped, or I was raped, but if you don't find me raped, he touched my breast.
Yeah, exactly.
Right? Yeah, right. So it can't be one or the other. So if they're saying no to the first one, what's the basis, the evidentiary basis for finding sexual assault? And to your point, there wouldn't have been any evidence of that, which suggests, I'm not saying this is true, but it could be potential juror misconduct. Maybe Trump's lawyers now need to look into and interview, by the way, some of these jurors and find out what was discussed. Just so your listeners know, after a trial is over, most of the time lawyers can hire investigators, track down jurors, and question them. Hey, what happened? What happened in that jury room? And this is a case where maybe that should happen.
Because as a logical matter, either you believe the plaintiff and her two friends, or you don't. And they're not claiming that he only went this far and no further. They're claiming he went all the way.
Yeah, no, that's really, if you ever quit TV and radio, maybe the legal world is up your alley. It really is an excellent point, because she's on the stand. She's not like a prosecutor that argues, like in a criminal case. Prosecutors can argue, oh, I want you to find so-and-so guilty of first-degree murder, but if you don't find them guilty of first-degree murder, then second degree, or involuntary manslaughter. That's okay for a prosecutor to do, right, in a criminal case. But in a civil case, in a sexual assault case, you can't do that. It can't be one or the other. And to your point, she didn't even do that. She put all her eggs in one basket. I was raped. Jury says, no, you weren't. We don't find you were raped, but we're finding you were basically groped, and touched inappropriately by Trump. And to your point, what is the evidence that supports that? And that, again, suggests to me that there might have been some shenanigans going on in the jury deliberation room where jurors are bartering, right? Let's meet in the middle on this. Well, that's not how the process is supposed to work.
So what happens now in a case like this? Are they able to raise that issue and these others on appeal?
Yeah, that's a great question. So in terms of the juror misconduct, that would be something for what's called a motion for a new trial. And that's why lawyers for Trump should probably get on it in terms of trying to talk to some of these jurors to find out what went down. Get investigators, go try to talk to them. Because then what you have to do, Mark, is you would file a motion for a new trial based on juror misconduct. But you need to support that. You need affidavits from the actual jurors, right? Where they might say what I just said. Hey, I didn't think he, sexually assaulted her, but I, decided that to meet in the middle, right? That would be inappropriate. But you'd have to get affidavits from the jurors, file a motion for a new trial based on juror misconduct. That happens before an appeal. The issues regarding letting in evidence of these two other ladies and the Access Hollywood tape, that would be for an appeal, and you don't file a notice of appeal until there's a final judgment in the case, and there hasn't been a final judgment entered yet. And then you have 30 or 60 days to file a notice of appeal. But I'm sure Trump's lawyers are going to clearly appeal. But look, you raised a good point, and I think they might want to pursue potential juror misconduct in a new trial.
Mm-hmm. Well, listen, you've been terrific. I want to thank you, Brian Claypool. We might want to pull you in again someday.
Yeah. Hey, can I tell you one other thing? It's really interesting.
Absolutely.
Civil cases. To your point again, you made an excellent point. In a civil case, the plaintiff has to prove by preponderance of the evidence. What does that mean? It's 51 to 49. It's not 50 to 50, right? To your like you were kind of suggesting earlier, like even if it's a stalemate, right? With these jurors, that a stalemate is not good enough. It's got to be 51-49. Anyway, I think that's just an interesting component on the integrity of the verdict. But thanks for having me.
Listen, you've been great. Brian Claypool, thank you, my friend, and you take care of yourself.